Pleading is the beginning stage of a lawsuit in which parties formally submit their claims and defenses. Pleadings are statements in writing of each party containing contentions of each party and detail of his case. Pleading is defined in Order 6 of the Code of Civil Procedure as plain or written statement. Fundamental rules of pleading. First rule is pleading must state facts and not law. The second rule is only the material facts must be stated. The third rule is pleading should not include the evidence. The fourth rule is the facts stated must be in concise form. Object of pleading. First is the object of pleading is to bring the parties to an issue. The second object is purpose of the rules relating to pleading is to prevent the issue being enlarged. The third rule of pleading is parties themselves know what are the matters in dispute and what facts do they have to prove at the trial. Every pleading shall contain only a statement in a concise form of the material facts, in which the party pleading, plaintiff or defendant, relies for his claim or defense, as the case may be. It shall not contain the evidence by which they are to be proved, which means that pleading should not contain any evidence. Now in Civil Procedure Code, where these rules are explained. Order 6 deals with pleadings in general. Order 7 deals with plaint. And Order 8 deals with a written statement. And now what are the rules which are comprised in Order number 6, 7 and 8? First is, in pleading, state your whole case, set forth in pleading all material facts on which you rely for your claim or defense, as the case may be. Secondly, it shall be divided into paragraphs numbered consecutively. Dates, sums, and numbers shall be expressed in figures. Second, in pleading, state facts and not the law. Do not mention the laws that apply to your case. If any matter of law is set out in your opponent's pleading, do not plead to it. In pleading, state only the relevant facts on which you rely, and not the evidence by which the facts are to be proved. In pleading, state material facts and only omit immaterial and unnecessary facts, and do not plead to any matter which is not against you. In pleading, state the facts of the case concisely but with precision. Briefly, we can say that it is sufficient to state the effects of document as briefly as possible. The seventh rule is, it is not necessary to allege any matter of fact which the law presumes in your favor or as to which the burden of proof lies upon your opponent party. The eighth rule is, the party should not plead conclusion of law in pleading. The ninth rule is, legal pleas such as stoppel, limitation, and res judicata or res sub judice, etc., may be pleaded in written statement. The 10th rule is, in cases where the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, particulars shall be stated in the pleading. Now let's define plaint. Plaint is the statement of claim in writing and filed by the plaintiff in which he sets out his cause of action with all necessary particulars. And secondly, plaint is the first process in inferior court in the nature of an original writ, whereby a party seeks remedy from court for the redressal of his grievances. Let's see what is written statement. A written statement is a statement of defense in writing and filed by the defendant in which he deals with every material fact alleged by the plaintiff in the plaint. In the written statement, the defendant can state any new facts which he considers to be in his favor. In the written statement, defendant can raise legal objections to the merits of the case prescribed by various laws, that is, plea of limitation, plea of estoppel, plea of res judicata. Let's now find out what is rejoinder. Rejoinder means answer of the plaintiff which he gives keeping in view new facts alleged by the defendant in written statement. Can rejoinder also have a written statement or the additional reply? The additional written statement is exactly for that purpose. It means further answer of the defendant, if court permits, which he gives in response to rejoinder. Pleading MCQ 1. Order 6 of CPC deals with A. Pleading, B. Submission of written statement, C. Both A and B, and D. FIR. The second MCQ is, as per principle laid down in Order 6 Rule 2 of CPC, pleadings needs to state A. Material facts, not evidence, B. Evidence, none of the above, and D. Both A and B. Thank you for watching this video. Please like, share and subscribe.